Small GST taxpayers need to keep tabs on demand notices. The Supreme Court recently upheld the action of the Patna High Court in discussing a writ petition filed by a taxpayer against a GST assessment order. The order in the case of Vishwanath Traders has wide ramifications for SMEs, MSMEs, small business persons, and professionals, as many of them, owing to a time lapse in filing of an appeal, approached the High Court directly for remedy action against a demand notice. Sunil Gavawala, founding partner of a CA firm, said that a response appeal to a demand notice must be made within 3 months. In case of a delay, the jurisdictional appellate commissioner can be approached for seeking 1 month extension. In case more than 4 months have passed, the only recourse available is to file a writ with High Court. As the assessment orders, which could contain significant demand, are served online through the GST portal, many small taxpayers do not keep track. Very often, the 4 month period passes before they are aware of the demand raised. Manish Gadia, partner of GMG and Company, our firm of chartered accountants, said the process of serving notices online through the common portal first began in financial year 2020-21. Unfortunately, small taxpayers do not have the bandwidth to check the portal on a day-to-day basis. In the case of many such taxpayers, notices and demands have piled up. To make matter worse, since the past few months, bank accounts are being attached for non-payment. Typically at this stage, the small taxpayers become aware of the notice. According to tax experts, emails and text messages informing the taxpayer of a demand notice that is uploaded on the portal are not always sent. Further, the contacts provided by an SME, MSME are typically those of an employee, and high attrition means such messages do not serve their purpose. When the apex court agreeing with the action of the High Court in not entertaining a writ petition, this path becomes challenging. Though correct legal interpretation, the Supreme Court's order literally closes all doors available to such taxpayers, stated Gawawala. If the avenue of filing a writ petition is shut, the entire sum will have to be paid. More often than not, the tax demand is high pitched and substantial penalties are imposed. Plus, there is an element of mandatory interest, added Gawawala. Both tax experts hold the view that it is important for SMEs to be more vigilant in checking up on demand notices. The government may also consider amending the Act to permit delay of appeal in genuine cases of SMEs and small taxpayers. Source: The Times of India. Thank you.